Hey everyone, and welcome to this explainer. Look, planning a South Carolina wedding means juggling a million things, right? You've got venues, caterers, the dreaded guest list. The absolute last thing you need is a bureaucratic hiccup completely derailing your big day. So today, we're giving you a totally stress-free guide to navigating the Palmetto State's marriage laws. Plus, we're going to show you how to actually get paid $50 just for getting prepared. Yeah, you heard that right. South Carolina will actually reward you with a $50 tax credit just for taking a premarital course. It's totally true and honestly a pretty great perk. We're going to show you exactly how to claim that money a little later in this explainer. All right, let's dive right into this. Here's our agenda for today. We'll start with eligibility and IDs, then move on to how and where to apply, waiting periods, costs and tax credits, the ceremony and officiants, and finally, pitfalls to avoid. Okay, Section 1, Eligibility and ID Requirements. So when it comes to age, the rules are super clear. If you and your partner are 18 or older, you're golden. No parental consent needed at all. However, the absolute minimum age to get married in South Carolina is 16. And if you are 16 or 17, the state heavily enforces some pretty strict documentation rules. You're going to need to present an original or certified copy of your birth certificate, and your parent or legal guardian has to actually show up with you in person to provide their ID and a notarized, sworn statement of consent. Now, for everyone applying, you've got to get your paperwork sorted early. Both applicants must provide a valid government-issued photo ID. We're talking a driver's license, passport, military ID, or state ID. But here is the one thing you absolutely cannot forget. Proof of a social security number is a literally non-negotiable requirement. Whether it's your actual physical social security card or an alien identification document for resident aliens, you must have it with you to proceed, no exceptions. Moving right along to Section 2, how and where to apply. In South Carolina, these applications are handled at the county level by your local probate court. What we're looking at here is the standard state of South Carolina application for license. Now, traditionally, both applicants have to appear together in person to sign a sworn statement. But, technology is finally catching up. Charleston County, for instance, offers a live online virtual e-application. They actually call it the Love System, which is kind of perfectly named. It lets you upload documents and apply entirely remotely. But just keep in mind, for most other counties, you're still going to need to plan a date to visit the courthouse together. All right, Section 3, waiting periods and validity. Let's talk timing. Okay, this is absolutely crucial. South Carolina has a mandatory 24-hour waiting period. By law, from the exact minute your application is filed, you have to wait a full 24 hours before that license can actually be issued and picked up. There are zero emergency exceptions to this rule. Please do not try to apply the morning of your wedding. And once the ceremony is over, your officiant has to return the signed license to the probate court, usually within 15 to 30 days, depending on the county, just to make sure there is an official legal record of your marriage. But here is a seriously awesome and pretty surprising fact. For the vast majority of counties in South Carolina, once that license is physically in your hands, it typically never expires. I mean, that is a huge weight off your shoulders. You can apply weeks or even months in advance when you're just in town scouting venues, and the license will just patiently wait in your folder until the big day. Just a quick heads up though, a rare few counties like Richland might have local expiration windows, so always double check. Up next, Section 4, Costs and Tax Credits. Let's talk money. So application fees depend entirely on the county you apply in, and they swing pretty drastically. In Lexington County, it's just a flat $30. Down in Charleston, it's $70. But up in Greenville, your residency actually matters. It's $50 for county residents, $75 for state residents, and a whopping $115 if you're from out of state. And please, always check your specific county's payment rules. Some courts like Spartanburg are cash only. You definitely don't want to get caught off guard there. Now back to that $50 reward we talked about at the start. Under South Carolina law, couples who complete a qualifying premarital education course get a $50 non-refundable state income tax credit. Here's exactly how you do it. Step 1, complete a 6-hour premarital course by a licensed professional or an ordained minister. You can actually do these entirely online, and they usually cost around $25. Step 2, immediately download your official signed certificate of completion. And step 3, hold on to that certificate. When tax season rolls around, just submit it with your state taxes to claim your $50 credit. The course basically pays for itself. Section 5, the ceremony and officiants. Who actually has the power to marry you? South Carolina Code is really specific on this. It says only ministers of the gospel, Jewish rabbis, officers authorized to administer oaths in this state, and the chief or spiritual leader of a recognized Native American Indian entity are authorized to administer a marriage ceremony. But that one little phrase, officers authorized to administer oaths, that is your secret weapon. Because the South Carolina Notary Public falls directly under that authorization. This is a total game changer. It means a friend or family member who becomes a commissioned SC notary can legally officiate your wedding. How cool is that? Finally, Section 6, Special Cases and Pitfalls. Let's make sure things go smoothly. If you're planning a destination wedding in gorgeous spots like Charleston, Myrtle Beach, or Greenville, you can rest easy. You do not need to be a resident of South Carolina to get a marriage license there. And even better, a license obtained in any South Carolina county is perfectly valid statewide. However, there is a very hard geographical line here. The actual marriage ceremony must physically occur within the borders of South Carolina. You can't just grab an SC license and then get married right across the border in North Carolina or Georgia. Let me put on my wedding planner hat for just a second and summarize the biggest missteps you have got to avoid. First, forgetting physical proof of your Social Security number. They will turn you away, no questions asked. Second, bringing a credit card to a cash-only probate court. Always verify how they want to be paid. Third, ignoring that mandatory 24-hour wait and trying to apply on the day of the wedding. Just don't do it. And finally, jetting off on your honeymoon and forgetting to have your officiant return the signed copies of the license. If it doesn't get returned, there is literally no legal record of your marriage. Now, just a quick professional heads up. While this explainer is a super detailed guide based on current state statutes and county rules, laws, and local procedures, do shift from time to time. Your local county probate court always has the absolute final say on current procedures, fees, and requirements. So just give them a quick call or check their website a few weeks before your big day to make sure you're all set. Well, we've covered the wait times, the paperwork, the fees, and the incredible flexibility of notary officiants. So I'll leave you with this to think about. Are you going to invest 6 hours of your time in an online premarital course to strengthen your bond and snag that $50 tax credit? Or are you just going to jump straight to the courthouse and pay full price? Whichever route you choose, I wish you a perfectly smooth planning process and a lifetime of happiness. Thanks so much for joining me on this explainer, and hey, be sure to share your own wedding planning strategies down in the comments.